You were Mr. Abbasi? So you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 12th, 2026, at approximately 12:01 in the morning, an officer conducted a traffic stop on a silver Chevrolet at the 12,500 block of North Freeway, which is in Harris County, Texas. The officer working undercover advised he observed the same vehicle performing multiple donuts in the parking lot of Texas Thrift. This is located at 2325 FM 1960 West, and the vehicle nearly struck pedestrians and other vehicles. Officer maintained visual until deputies arrived, ensuring no one else entered or exited before the stop. Deputy Martinez, the officer stopped the Camaro and identified the driver as the defendant. The defendant was detained, and when asked why he was driving recklessly, he stated he was just trying to have fun with his newly purchased vehicle.
Does he have a license to drive? Guys, do you mind running it? Mr.
It was written in the screen that it's eligible.
It is eligible. All right. Mr. Abbasi, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to drive in this manner again. Racing, reckless driving, donuts, street takeovers. If you do, I will put you in jail. There will be no more PR bonds for you. You understand? You are on felony probation. You're supposed to live like you have a halo above your damn head. It's very possible to issue a felony warrant for your arrest at this point. We are going to reset your case to give you time to hire a lawyer. We'll have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. You are not allowed to drive unless you have valid liability insurance as well. You understand me? If you drive without a valid license or insurance, I'm going to just throw your ass in and I will give you a high bond. I will deem you a public danger. You understand me, Mr. Abbasi?
Yes, Your Honor.
All right, come on. So, no reckless driving, donuts, racing, etc. Please.
We have the interpreter here.
Yeah, let's do it. Come on, for sure.
On page 11, Judge.
You were Mr. Mendez. Mr. Mendez, you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 17th, 2026, an officer dispatched for the 4430 Rosebud Drive. This is a public roadway in Harris County, Texas. There was a witness who stated the defendant had attempted to make a left turn, but failed to yield the right of way and hit her. The defendant had a strong odor of alcoholic beverage in his breath. The defendant stated that he purchased and drank The defendant stated that he purchased and drank a bottle of tequila. The incident occurred at 11:17, and the driver stated he last ate a salad at 12, which is actually after the incident. The SFSDs were 6 out of 6 of the HGM, 4 out of 8 of the walk and turn, and he was unable to do the one leg stand as he was only doing the walk and turn. The DIC was read with Spanish audio, and he blew a .212 and .214.
Oof. Does he have a license to drive?
Eligible, Your Honor.
Mr. Mendez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol illegal drugs, or unprescribed controlled medication. You do not have a Texas driver license. You are not allowed to drive. I don't care what you have to do in this life. Mr. Mendez, look at me. You will be signing a promise with me. This is an affidavit that you will swear to today that you're not going to drive. Like I said, I don't care that you have to work. I don't care that you need groceries. I don't care that a child has to go to the hospital. You do not have a license, therefore you are not allowed to drive.
Sir, his license is eligible.
It is eligible.
Yes, sir.
Are you sure?
Yes, I can rerun it.
Please. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, then likewise, do not drive. That is also a condition of your bond. If I find that you consume alcohol, I will revoke your bond and put you in jail. Do you understand?
Yes.
Okay. We are going to reset your case to give you time to hire a lawyer. So
Es Manuel.
let me see. Are you expecting them here today? Who is it?
Manuel.
I think.
Oh, Emmanuel Newley, probably. That's what it probably is. All right. So what we'll do for now, Mr. Mendez, we will have you fill out all the paperwork. We will have you sign all the conditions. Have you ready? When your lawyer does arrive, we'll give you guys a reset. Do not leave until your lawyer gets here, though, and then you sign all the appropriate paperwork. For now, we'll have you sign a reset. I'll have you sign the conditions, and then we'll just have you waiting back. Please.
Sir, should I call him to see?
Don't worry, he'll be here.
Okay. Your Honor, the license was eligible.
Yeah, got it.
Go ahead and sign.
Thanks. Is that it? Is that it?
As far as Spanish speakers, yes, ma'am.
Okay, thanks, Tony.
Now let's on page 3, Judge. Nicholas.
Canales is the next one. All right, good morning, Mr. Canales. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 17th of 2026, at approximately 2:24 in the morning, officers conducted a traffic stop after observing the defendant's vehicle traveling eastbound on Kidwell with expired registration. Defendant consented to a search of the vehicle, and inside the center console, officers located a holstered silver Smith & Wesson and multiple marijuana blunt ends containing usable quantities of marijuana. The marijuana was later weighed at 1.81 grams, which is a usable amount, and based on its green color, leafy texture, packaging, and officer/narcotics unit confirmation, the substance was identified as marijuana. The firearm and marijuana were both within reach of the defendant, and his driver's license is not eligible.
So was the gun in plain view or was it inside of the actual?
The defendant consented to a search of the vehicle.
He did? I got it. Okay. Mr. Canales, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to drive. You do not have a license. I don't care what you have to do in this life. Do not drive. You're telling me that he doesn't have a license, is not eligible, correct?
Yes, Your Honor.
So you do not have a valid Texas driver license. Do not drive. Do you understand? It is your responsibility to figure out what the heck's going on with your license, but until that point, and you come back and get approval, if I find that you drive, I will put you in jail and I'm going to make your bond high. Do you understand?
Yes, sir.
You will be signing an affidavit with me today promising me you're not going to drive. There's nothing in this life that you can justify getting into a car and driving. If you drove here, you cannot drive home. You understand? Also, as a condition of your bond, you're ordered not to be in possession of any weapons as well. No weapons, no driving. If you get your license If you get our insurance, come back and we can talk, and then I can take this restriction off. I'm just asking you to follow the law. If I find that you try to do stuff on your own and you violate this, I'm just going to go bananas on your bond. Do you understand? I'm not asking much from you. Guys, do you mind filing no weapons for Mr. Canales, please?
Yes, Your Honor.
All right, we are going to reset your case to give you time to hire a lawyer. I will have you come up here, swear to us that you're not going to drive. I'll have you sign a reset. We will have you take a seat while we get the bond conditions. Once you sign them, at that point, you'll be free to go. All right,
Over here.
come on.
Over here. Right here. Do you solemnly swear that you will not drive without a valid driver's license? Over here.
Yes, yes.
All right, good morning, Mr. Davis. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
An officer dispatched a follow-up of an alleged act of unlawful violence that occurred on December 27th, 2025 at 7400 Katy Freeway in Harris County, Texas, March 19th of 2026. Officer contacted a defendant witness who stated she was in a relationship with the defendant for 6 years. While driving to a football game, the defendant stated, "You always pick and choose what you want me to do. I don't want to be with you." The complainant replied, "Okay, I don't want to be with you either." The defendant replied, "I'm not going to buy anything to the house," which the complainant replied, "You're not a man." From there, the complainant stated that the defendant was driving around the area of 7400 Katy Freeway in Harris County, and the defendant struck the complainant with the back of his right open hand on the complainant's face, causing physical pain. When the complainant stated once she was struck in the face, the complainant stated that she was covered her face with her hands, and then the defendant started striking the complainant several times on her hand, causing physical pain. From there, the complainant threw her drink at the defendant, making it difficult for the defendant to drive. And then the complainant called the police, found the police to the location. The officer observed injuries consistent with the statement.
All right. Mr. Davis, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with this person whatsoever. If you do, I will revoke your bond, put you in jail. There will be no more PR bonds for you. Additionally, while you're on bond for this assault case, no possession of any kind of weapons or ammunition. If you violate these conditions, I only have one place for you. Do you understand?
Yes.
Do you have the ability to hire a lawyer?
Yes.
We will give you time. I'm going to have you sign a reset. We'll have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. There is a protective order that has been issued in this case. You need to get to know it. If you do something to violate this protective order, like go to the complaining witness's house, place of work, have contact, they can file an additional case against you, and a violation of protective order is one of the worst cases you can pick up. You understand? Okay, please. No weapons, no contact.
Austin?
What's the last name?
I'm sorry,
What's the last name?
Austin on page 7, it's top seven.
Okay. All right. Good morning, Mr. Hoskins. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 18th, 2026, officer conducted a traffic stop at 14742 White Heather Drive, which is in Harris County, Texas, After the officer observed the vehicle displaying expired registration, the driver, identified by his Texas driver's license, was the defendant and was operating the vehicle. In plain view on the dashboard, the officer observed an unholstered tan or black Glock pistol with a fully loaded magazine inserted in no round chamber. A criminal history check showed the defendant had a prior unlawful carrying of a weapon charge.
All right, Mr. Hoskins, I'm going to find that there's probable cause to go forward with your case. While this case is open, just no weapons. Do you understand? Do you have the ability to hire a lawyer?
By this point, the focus had shifted from the alleged crimes themselves to what happens after release. The judge repeatedly explained that bond comes with strict responsibilities. Public safety, not convenience, would determine every decision.
Okay, we will give you time. I'm going to have you sign a reset. We'll have you take a seat while we get the bond conditions. Once you sign them, at that point, you'll be free to go. Don't have any weapons. I don't care what the excuse is. Do you understand? Okay, please. Good morning, Mr. Lopez.
Good morning.
You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On July 19th of 2026 at 1:28 in the morning in Harris County, Texas, on a public roadway, an officer observed a vehicle going 91 miles per hour in a posted 64-mile-per-hour zone. The officer obtained this reading by using his in-car radar while stationary. The vehicle switched multiple lanes of traffic unsafely and without signaling from lanes 1 to lane 4 in attempts to blend in with the heavy traffic. Once the driver noticed the officer was trying to catch up, the driver switched lanes once again from lane 4 to lane 3. And due to how fast the vehicle was traveling, it almost rear-ended another car just in front of the white Toyota. The vehicle also had unconfirmed insurance. After a traffic stop was conducted, a strong odor of marijuana. The officer observed a strong odor of marijuana, and the defendant stated it was just a little bit of weed in his car. About 0.17 ounces were recovered, and the officer also recovered a Ruger gun located in the trunk.
Now, Mr. Lopez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons while this case is open. Just don't. Do you understand? If I find that you do, I will revoke your bond and put you in jail. There will be no more PR bonds for you, sir. We'll have you sign a reset. We'll have you take a seat in the jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. When you come back, please have a lawyer.
Well, I'm saying, McDowell.
So no weapons, please. That jump.
Susan?
You were Mr. McDowell? Mr. McDowell, you're charged with 2 cases. You're charged with driving while intoxicated and failure to stop and give information. On both of those cases, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 17th of 2026 in Harris County, Texas, on a public roadway, a motor vehicle hit a marked police car and fled without giving information. The police broadcast the make and model of the car, and the other police were able to stop and detain the defendant. The police noted glossy eyes and slurred speech, but the defendant denied being in a crash despite the damage to his car. The officer conducted SFSTs, and they were 606 on the HGN, 7 out of 8 on the walk and turn, and 3 out of 4 on the one leg stand. The DSD was read, and a blood draw was consented to.
So you said there was a crash and you ran? So-
Hit a marked police car.
Mr. McDaniel, I want to find that there's probable cause to go forward with your case. Does he have a valid Texas driver license? Does he have any prior DWIs?
No pressure.
No priors? Okay. Hey, Mr. Hines, before you leave, we need to talk about McDaniel, please. So do not leave until we talk about him because we need to talk about his bond. Okay, thanks. All right, Mr. McDowell, as a condition of your bond, you are ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using anything illegal, including marijuana, I will revoke your bond and put you in jail. You are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a condition. If I find you drive without insurance, I will revoke your bond and put you in jail. Do you understand? Yes or no?
Yes.
Do you have the ability to hire a lawyer, Mr. McDowell? We will give you time. I'm going to have you sign a receipt. We will have you take a seat. You'll get with Veronica for your bond conditions, and after that, you'll be free to go. Don't make any unwise choices. I'm going to protect my community at all costs, Mr. McDowell. You endanger it. It's just not going to go well for you. Do you understand? You will get no more warnings, sir.
Bossy?
Mr. O'Connor, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. We were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 18th of 2026 at 1:21 in the morning, an officer observed a motor vehicle missing a tire that was also stalled on a public freeway. The officer was able to move the defendant to a parking lot and noticed the strong odor of an alcoholic beverage in the defendant's breath and person. The defendant was also sweaty and leaning against his motor vehicle for balance. There were 2 empty 12-ounce beers in the car, as well as the defendant admitting to drinking 5 12-ounce beers before leaving work. The defendant did not know how he lost his tire, and the officer also used bloodshot eyes. The SFSDs were conducted, and they were 6 out of 6 on the HGM, 5 out of 8 on the walk and turn, and 2 out of 4 on the one leg stand. The DIC was read, and he blew a .167 and a .166.
Mr. O'Connor, I'm going to find that there's probable cause to go forward with your case. I would venture a guess at a damn elementary that you're not to have alcohol in the car while you're driving. As a condition of your bond now, you're ordered not to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, you will go to jail. You're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, including marijuana, into jail you go. There will be no more PR bonds for you. Do you understand? Do you mind filing the guardian interlock? Please,
Okay, I will.
paperwork. We are going to reset your case to give you time to hire a lawyer, so I will have you sign a reset. We're going to have you take a seat while we get all the bond conditions. Once you sign them, at that point, you'll be free to go. Oh, wait a second. Does he have a license to drive?
It's eligible, Your Honor.
Prior to DWI?
Here, no prior.
Okay.
Hold on.
Peters. Peters. Good morning, Mr. Peters. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On November 3rd of 2023, officers were dispatched to the Red Roof Inn in Harris County, Texas. Officers met with the complaining witness, who stated that the defendant, who's her brother, were in a verbal argument when the defendant got in her face. The defendant pushed the complaining witness and grabbed several of her braids, pulling them out of her scalp. The complaining witness ran into the hallway, and the defendant grabbed her and started punching her multiple times in the face and on the head, causing pain and injuries. The manager of the Red Roof Inn was provided partial video of the incident showing the defendant assaulting the complainant.
So they have it on video. Is that what you're saying?
Video.
Partial. Okay. Mr. Peters, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this complaining witness. Do you understand?
Yes, sir.
I don't care what you need to do. I don't care what she's got of yours. Just don't have any contact with her. You're also not to be in possession of any weapons.
Yes, sir.
If you violate this, I will order your arrest. I will put you in jail. There will be no more PR bonds for you. Do you understand? Do you see a protective order that has been issued by chance, Mr. Peters? That's a no, right? No? Okay. I am entering now what's called a magistrate's order for emergency protection that identifies Ms. Jackson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.07 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this, they can file an additional case against you, and a violation of protective orders. Just, you understand?
Yes, sir.
All right. I'm not asking for much, man. I just want my community protected and I'll do it at all costs, really. So I'm going to have you sign a reset. We'll have you take a seat while we get the bond conditions ready. Once you sign them, at that point, you'll be free to go. When you come back, please have a lawyer. Come on. Ramona, we need him to sign the MOA after he's done, please. Hold on. Can we handle Mr. Thering first? Mr. Thering, who's your client?
Stephen Holtar.
Good morning, sir.
Good morning. How are you, Judge?
How are you? Great to see you. It's Overter.
Judge, page 7.
Yep. All right, Mr. Hoveter, you're charged with driving while intoxicated, second offense. Okay. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 18th, 2026, an officer responded in Harris County, Texas for a medical emergency involving a driver who was unconscious inside a vehicle. The deputy observed defendant's vehicle stationary in the roadway with brake lights on, engine running, and transmission in drive. The driver and sole occupant, identified by his Texas driver's license, was the defendant who was unconscious and unresponsive to loud commands, lights, and knocking. While entry was being forced into the vehicle, the defendant woke and drove forward, nearly striking a marked patrol unit. Deputies ordered the defendant to place the vehicle in park and exit. Upon removal, deputy noticed a strong odor of alcohol, slurred speech, confusion, and balance issues. SFSTs were conducted at a nearby gas station. The defendant displayed 6 out of 6 for the HGN, 6 out of the 8 for the walking turn, and 3 out of 4 for the one-leg stand. Two witnesses stated they observed the defendant earlier driving erratically, weaving into other lanes, nearly striking vehicles, driving under the speed limit, and stopping past marked intersection lines. They followed him for approximately 1.7 miles while contacting police until he stopped at the intersection and lost consciousness. Both confirmed he was the sole occupant. The defendant refused a breath sample after DSC warnings, and a blood warrant was obtained and executed. And a criminal check revealed his prior DWI conviction. His driver's license is open.
Got it. Mr. Hoverter, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you like crazy to make sure you're not using. If you have a problem with drugs or alcohol, now is the time for you to address it. Because if you don't, I will do it for you. And if you don't believe me, ask Mr. Thering. We have butted heads on more than one occasion because of issues that have come up with clients. As much as I love him, I don't give a rat's behind. You violate any of these conditions, you endanger my community, I'm going to throw your ass in there and I will make it sky high. Do you understand? You are not allowed to use any car that doesn't have an ignition interlock on it. If I catch you driving a car without an interlock, then likewise you will go into custody. I send notice to DPS in Austin so that every police officer in the state knows if they pull you over, whatever car you're driving doesn't have an interlock, they're going to take you to jail. Do you understand?
Yes, sir.
I'm not going to warn you again. If you violate these conditions, if you fail to blow in this device, if you test positive for anything illegal, including marijuana, it's just really not going to go well for you. Because you have a lawyer already, I will waive your appearance. It is your responsibility to stay in touch with Mr. Thering. He'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you because you're playing games, then likewise, I will revoke your bond. Do not pick up any new cases. You understand?
Yes.
Okay. Great to see you.
Likewise. Briefly, Your Honor.
Before every defendant left the courtroom, the conditions were unmistakable. No illegal drugs, no unauthorized driving, no weapons, and no violating protective orders. Whether each defendant returns to court or returns to jail now depends on the choices they make.